and he has also spent 25 years with the Public Citizen Litigation Group, a public interest law firm here in Washington, where he has handled multiple cases before the United States Supreme Court and more than 60 cases before federal courts of appeals and state courts of last resort. He is a senior fellow with the Administrative Conference of the United States and an elected member of the American Law Institute. He is also a scholar with the Center for Progressive Reform. Welcome, David Vladeck.
So I spent a mere 25 years working for Ralph. I will never forget my interview with Ralph. The first question was, did you read the paper today? And yes, I had. And he said, okay, what made you really mad? And so let me talk about what makes me really mad about the state of consumer protection in the United States. So Ralph talked about the blasphemy of what's going on with food protection. Well, the blasphemy about consumer protection in the United States these days is that very strong notions of freedom of contract are essentially corroding what we think of consumer protection. And this is a pincer movement that comes from two angles. One comes from essentially the disintegration of tort law contract law as we know it. These days, consumers ordinarily have no bargaining power with respect to the contracts they sign. These are often, the I accept little box at the end of a form contract that you may or may not read. In many instances, consumers are not even presented with the contract prior to entering into them. The contract is available, if at all, after the fact. And in those contracts, there are generally provisions that would have been unthinkable 30 years ago. So one common provision gives the seller the unilateral right to modify the contract. So if the seller decides, well, I think I can sort of eke more out of this relationship with the consumer, they're free to modify the contract and send you a little note down the road. There are all sorts of bombs put in these contracts that often go off to the detriment of consumers. So one, and I'm going to come back to this, one sort of ubiquitous contract provision these days is a mandatory arbitration provision, which requires consumers to go to a privatized system of justice that's essentially invisible rather than exercising their rights in court. But I'm going to come back to that. But there are other waivers that are generally attached to modern contracts. For example, forfeiture of remedies that one might be entitled to under statute. So for example, in many cases that involve contracts, a disappointed consumer would have the right to have his or her case heard before a jury. Well, contract provisions these days often include waiver of the rights of jury trials. Contracts also include the forfeiture of remedies that would otherwise be available to the consumer under state law. Many of the contracts you've entered into require you forfeit your right to punitive damages. You forfeit your right to statutory damages. Often statutes contain what are called liquidated damage provisions, provisions in which certain amount of damages are assumed. Those provisions are also those rights, statutory rights, are often waived in contracts. So you're asking, wait a minute, these are statutory rights. These are rights Congress thought were important enough to enshrine to statute to guarantee the consumer has this remedy in the event of breach. How could those rights be waived? Well, the Supreme Court has held in many cases that arbitration substitutes the procedures and indeed oftentimes some of the substance that would otherwise be available if resort to court were available to the consumer. So for example, the Supreme Court has upheld arbitration agreements even where it is clear that a statutory right cannot be vindicated in arbitration. So even where it is clear, this is a case called Italian Colors, where rights that Congress thought were important enough to enshrine in statute could not be vindicated through an arbitration agreement, tough noogies. The right is now unenforceable. And class action provisions also often include sacrifice of procedural rights that would otherwise be available. If you sue in court, you have certain rights of discovery. You can get access to the other side's documents. You may be able to take oral statements, depositions of witnesses who have information that's pertinent to the case. Class action rights are often afforded by statute that are abrogated by contract. So the kinds of form contracts that we see today not only deal with the underlying transaction, but include essentially a long list of rights that consumers forfeit by entering into a contract. And the courts have shown no interest in pushing back. Making matters worse, the court's arbitration jurisprudence has been essentially go away to consumers. There are a number of cases involving forum contracts, a case involving AT&T, where the court split 5-4 on the enforceability of these consumer contracts that could only be vindicated by groups of plaintiffs suing together because the dollar amounts were reasonably low. And so one form of assault on consumer protection has been the courts enforcing contracts literally, even to the extent that they sacrifice statutory rights, and the Supreme Court's aggressive affirmance of private dispute, private ordering over transparent judicial proceedings where the public at least has some insight into what's going on. A second form of assault, and this gets back to Mike's point earlier about shrinking government. So 20 years ago, Grover Norquist famously said his goal was to shrink government to the size where it could be drowned in a bathtub. And in a large measure, he has succeeded. So if you look at the staffing of the important federal consumer protection agencies, they've been hollowed out. I was the director of the FTC's Bureau of Consumer Protection for 4 years. The FTC today is about 2/3 the size it was 20 years ago. The population of the United States has grown by 1/3 and the economy has doubled, yet the number of regulatory cops on the beat has shrunk. And if you go up and down the list of the regulatory agencies we all depend on for our health and safety, they are quantitatively smaller. I mean, my colleague, my former boss, Joan Claybrook, was head of the National Highway Traffic Safety Administration, responsible for overseeing auto safety, truck safety, tires, everything that moves. They have about 600 people to regulate the entire global automobile industry. Really? I mean, that is sufficient? The Commodities Future Trading Commission, a small agency, but has regulatory authority over most of the commodities traded in the United States, is about the same size. The FTC, which has both consumer protection and antitrust authority, has about 1,100 people, in contrast to the 1,600 that it had in the 80s and 90s. Even the CFPB, the new sort of, the first line of defense in terms of financial products and services, at the most will end up having about 1,400 people. So, when people rail against the size of government, you need to understand that with respect to the agencies we depend on to protect us in the marketplace, those agencies are very thinly staffed, they're overworked, and to make matters worse, the states, which used to be an equal partner in consumer protection matters, have also been hollowed out. When I was at the Federal Trade Commission, I worked very closely with colleagues in state attorneys general's offices. They too have been cut massively because of budgeting and other state restrictions. So to the extent that we depend on government to be our first line of defense against egregious misuse of marketplace power, The government does what it can, but it is a very thin line that is spread thin. And I want to echo another point Mike made, which is there's a lot of talk about agency officials being feckless, not being tough enough. Well, they're between a rock and a hard place. The tougher they are, the more they face funding cutbacks. When I was at the FTC, we were very aggressive, and I was called up onto the Hill with some regularity to basically say, you know, your funding is in jeopardy, and you've got to be careful. And so it's a very difficult position for federal regulators. Let me talk about one other market failure, which is the courts, too, have been equal partners in some extent in the ratcheting back of consumer protection. So take one field. So identity theft is now rampant in the United States. Last year, the Justice Department estimates that 17 million Americans were victimized by identity theft. I measure this because the Federal Trade Commission has essentially a self-help part of its website where people who have been victimized can go and get access to standardized police reports and other forms that they would need in order to try to reclaim their own identity. Last year, 500,000 Americans used that site in order to file claims about identity theft. So the identity theft is the predictable debris of an internet economy where data security is not taken seriously. And so this is an area where Congress has refused to act. The Federal Trade Commission and other agencies have asked for authority to force the people who store your data to take adequate steps to safeguard it. Ironically, of course, they safeguard their own intellectual property data very well. Your data, your payment card information, your social security number, the prescriptions you take, whatever other personal data these companies have is not very well protected. And part of the reason is because there's no economic deterrence for companies to have lax security. The courts have repeatedly turned away people claiming injury from identity theft. And the Supreme Court's recent decision in a case called Spokio versus Robbins still leaves unsettled the question about whether you have a right to sue when your personal data has been compromised due to a data breach. So, all right, so that's the assault. And the assault is real, and the erosion of our rights has been steady and predictable for the last, I'd say, decade or 20 years. So what can we do about this? Well, there have been some bright signs on the horizon. The passage of Dodd-Frank and the creation of the Consumer Financial Protection Bureau is an enormous step forward. Now, the agency has been in existence for only 4.5 years, but has already done some important things. It's taken some enforcement actions. It's done policy work to protect those people who are not entitled or not eligible for anything other than subprime loans, to protect them in the market. It has proposed some curtailment of the right to mandatory arbitration, but that's just a first step. That agency is under assault constantly in Congress. I talked to my friend Rich Cordray. He has stopped counting the number of times he's been hauled up to the Hill to testify. It was, I think, 50 at last count. He's only been there for a few years. We need more legislation, and in order to do that, we need to organize, we need to personalize these stories, and we need to look at the lever of powers that are available to us and tries to exercise power. So let me talk about a few things. One is, if you look at mandatory arbitration, Congress understands how powerful a force that is. There are exemptions to it. When Dodd-Frank was passed, the most fierce lobbying was not done by the banks. It was done by the auto dealers. Why? Because they wanted a provision in the bill that made it illegal for the auto manufacturers to require the auto dealers to arbitrate disputes. It's one of the few odd carve-outs in Dodd-Frank. Well, the auto dealers had a point, and we need to force Congress to take a hard look at arbitration, at mandatory arbitration. And the only way we're going to do that is if we come up with a number of stories that drive home just how unfair, undemocratic, and essentially how perverse that process is. The other thing that we need to do is we need to win the battle in the courts, and this is where you're going to hear from Paul Bland and people from Public Citizen Litigation Group early on. We've been fighting these battles in the court, but the court is now up for grabs. Justice Scalia's seat remains vacant. Justice Ginsburg is 83. Justice Kennedy is 80. Justice Breyer is 78. The next president will remake the Supreme Court in all likelihood. Most of the decisions that I've been fretting about have been 5-4 decisions. One vote can make an important difference, and one vote on November 8th can make a huge difference. Thank you very much.